Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about stays of administrative proceedings that are under appeal. Cases that should have gone to the Supreme Court of Canada, but didn't. A man involved in a complaint dispute with the College of Physicians and Surgeons in Alberta applied to appeal a finding that was made by the College of Physicians and Surgeons tribunal against him. He applied for the appeal and argued that the proceedings below, which were going to continue while his appeal was pending, should be halted and essentially stayed pending the outcome of his appeal. The college disagreed and refused to order a stay. He appealed and ultimately sought leave to the Supreme Court of Canada on this issue, who dismissed the application for leave. And this case does raise very important issues. When you have administrative tribunals, they are usually subject to supervisory authority from higher courts or from higher level tribunals. And so where people have rights of appeal either internally within those tribunals or externally to a superior court or a court of appeal for a province, it makes sense that the lower proceedings be paused, because if the person's appeal is successful, then they'll have gone through additional proceedings, additional time and expense, and additional slowing down of the wheels of justice for all of the other cases that could have benefited from using court or tribunal time that never needed to be used in the first place. It's unfortunate that the Supreme Court of Canada didn't recognize that this case wasn't just about this one individual application for a stay, but about a larger issue of access to justice and the proper respect for judicial and quasi-judicial resources across Canada. If there was a better framework in place for determining overall, when it comes to administrative decision-making, when a stay of the lower proceedings should take place pending an appeal, there might also be better guidance. But subjecting somebody through a full disciplinary process, including potentially the sanctions of the process, while an appeal of a decision is underway, seems to be inconsistent with our principles of judicial economy. And it's unfortunate that the Supreme Court of Canada didn't take this opportunity to hear this case and potentially save a lot of taxpayer money and a lot of resources and a lot of time. And unfortunately, the ultimate result of this is not just taxpayers on the hook for proceedings that may never have to happen or have to have happened, but also individuals on the hook for the costs associated with being taken through those proceedings when, again, they may never have needed to occur in the first place. Hopefully, the Supreme Court of Canada takes another opportunity to look at this issue and allows leave in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.